The first thing that I knew about it was the punch me square in the back of the head. So welcome back to the channel. So lots of people ask me about self-defense. They ask me how far you can go and what you can do, whether you can carry a weapon and all that sort of stuff. So I'd like to go through a few of those in this video and hopefully dispel some of the myths, give you some confidence that you can go out and defend yourself and tell you a few stories along the way. So one of the reasons I get to talk about self-defense quite authoritatively is not just because I'm a barrister and I know what the law is, but I've also trained in martial arts for many years. So I am arguably what you might call one of the world's leading experts on the use of force as it comes to actually applying it in self-defense. I am a 6th degree black belt. I've trained for almost 30 years in different martial arts, including Taekwondo, which is the one that I hold here. So I can speak with some authority on how to use levels of force, and you never know, I might actually demonstrate some of them for you in some of my upcoming videos, either here or over on Black Belt Secrets. So as I said, I have a couple of stories to tell you, and one of which is an attack upon me. So for this story, I was in another country and I wanted to explore some of the more traditional areas of the city where I really had no business being, because for the reason being I stuck out like a tourist, obviously with my cap and my sunglasses and my phone and my camera, and I looked like the perfect target for someone to mug, if someone was so inclined to mug. Now, I was walking along, I came across some sort of market, so I was browsing along all of the local items and the handcrafted things, and I was quite intrigued and minding my own business. And before long, and sure enough, some guy decided he wanted to mug me, but the first thing that I knew about it was the punch me square in the back of the head. Most people, I expect, would have been extremely shocked. They might even be knocked down. Most people in a state of fear and shock, their knees go weak and they get shaky because they get absolute panic and an oxygen euphoria, and so they really shake, their legs go weak and they fall to the ground. That's why a lot of people, when they are attacked, end up on the ground because their legs give way and they just give in to shock and fear. I didn't do that because I felt this punch on the back of my head, and the fighter in me, having trained for almost 30 years now and done countless bouts of 1-on-1, 2-on-1, 3-on-1, a crowd on one, and I've done this day in and day out for many, many years. So the fighter in me recognized that this was an attack upon me, and my instinct was not to run or to flee or to cower or to hide my head or anything else. My instinct was to turn around and square up, ready to fight. Now, you can probably guess that that's not what the prospective mugger had in mind. He didn't expect that I was going to turn around and fight him. So instead, he ran off. He took one look at me ready to fight him, and he did a runner. But not before I thought to myself, what's the reason that he's running? Has he already been successful in mugging me? Has he taken my wallet or something? Because I think I had some sort of bag on my hip or whatever, and I thought maybe he's taken something and he was trying to punch me to distract me or whatever. But the bottom line is, in that split second, I thought he'd taken something from me. So I gave chase. Now, I don't recommend this. Even if you're trained, I really don't recommend this. But at the time, I didn't really think about it. I just gave chase because the only split-second thought that I had is, he's got something, he's running away, I'm not going to let him get away, I'm going to go and get it back. So I gave chase. So I caught up with him a little bit further down the road, and he turned off to square up to me. Now, obviously, being in another country, I then realized there's a language barrier, not just between me and him, but between me and everybody else. Because I couldn't really communicate with him other than point at his coat and point at my pocket, almost to gesture, what have you taken from me? Which it turns out nothing, but I'll come back to that in a minute. So it turns out nothing was taken. He hadn't actually successfully taken anything from me. And just to add in at this point, while I'm editing, the guy even, as I found out, told the crowd that I'd attacked him. So the crowd initially were going to turn against me, but for one person telling the crowd that actually no, it was this guy mugging the foreigner, me, and making them all look bad. Just sort of throw that in there. And so instead, he retaliated by attacking me and the person that I was with, which I really took offense to. And so I intervened by standing in between him and the person that I was with, and I applied various pressure points and took him to the ground. And I pinned him on the ground whilst I was looking through his pocket to see whether he'd taken anything from me. Now, luckily, someone else then explained that they saw this guy trying to mug me to the crowd, and the crowd was not best pleased. So then the crowd decided that they were going to hold him here until the police arrived, and the police did arrive, and the police took him away after the crowd explained what had happened. And so the reason for telling you that story is that understanding self-defense is not just understanding the law in an academic sense and what you are or are not allowed to do, but the reality of the situation was so fast and so severe that even I did not really have time to think about it. Now, I reacted instinctively based on the training that I had. I didn't severely hurt him. I just did enough to restrain him, both to see whether he'd taken anything from me and so that he could be detained until the police arrived, which was successful. But in that split moment, the law does not, at least now talking about the law of England and Wales, does not require that you undertake an extensive consideration of the circumstances and whether it's necessary and reasonable and justified to react in the way that you do. The law understands that you may react quickly and instinctively, and that you are indeed allowed to react to defend yourself or someone else. So let's jump into the law and have a discussion about self-defense, what you can and can't do, what is or is not expected of you, and what might be considered a weapon. For example, if I were to take this tripod here, by itself it is just a tripod. But obviously, if I were to hit somebody with it, okay, just for a moment, it's time to get personal. I don't often get personal on this channel. I usually reserve that for BlackBeltSecrets, my other channel, which I'll link in the description below if you're not subscribed. But I think this warrants being on this channel because it reaches a wider audience. Now, many of you know that BlackBeltBarrister is not just a play on words. I am, in fact, a black belt. And so I've trained all my life. And so drinking water while I train has been a sort of staple habit of mine. It's apparently the easiest habit to form because you drink water every day for a period of so many days and it becomes a lifelong habit and you always drink water. So I always drink at least 2 or 3 bottles a day. But about a year ago, just under a year ago, I gave up drinking alcohol completely. Frankly, I felt like it was too much of a pattern in my life and I wasn't enjoying it, but it became a pattern. So I wanted to cut that out. So just as this motto, which I've had embroidered onto my belt, says, give yourself no choice. That's my motto. So I gave myself no choice but to stop drinking alcohol completely. It wasn't necessarily forever. It was for a period of time I just wanted to stop it. But when I stopped it, I realized the pattern that had become in my life. And I was very quickly happy that I'd removed that pattern from my life. But then I also got bored. So I started looking for something else to drink. I started drinking teas. I started drinking fizzy water, which was quite frankly boring. Now, I love drinking water after training, when I get up, when I go to bed, and so drinking water is a very good habit of mine. I enjoy drinking water. But in the evening, I was looking to something to replace alcohol, quite frankly, because normal water just seemed boring. So then, as luck would have it, these guys reached out to me. Holy. Now, I'd never heard of Holy, but it looked quite intriguing to me because I've always avoided, or at least tried to avoid, energy drinks and things like that because I just think they contain so many things that I just don't want to put in my body. I only want to put into my body that which I think is good for me, which was one of the reasons I decided to cut out alcohol. So they sent me these 3 varieties, one of which is an energy drink, one of which is a hydration drink, and one of which is an iced tea. It's really quite simple. You put the water in, you put the powders in, and you give it a shake. But the real test is, what do these things taste like? So I'm going to taste them for the first time right now. I've got 3 of them here. There's lots of flavors to choose from. And so for the hydration drink, I chose to try, first of all, the strawberry and kiwi, which is a sugar-free hydration drink with electrolytes and minerals, because as much as I hate European law, they were kind of right in the sense that water by itself is not the best thing to avoid dehydration. You do need electrolytes and minerals and things like that. And anyone that trains intensively, as I can assure you that I do, needs those electrolytes. So let's try this. Do you know, that's it's really tangy and it tastes like those sort of ice pop drinks used to have as a child. Really tasty. And I could see myself reaching, in fact, I feel like drinking more of it now. I can see myself wanting to drink more and more of it. And that's kind of exactly the point. It encourages you to drink more because it's so tasty. It really is tasty. I swear to you, I'm not just saying that. It's really tasty. I would drink the rest of it, but I want to try the others on camera as well. Now, I've not tried this one before. This is pomegranate piranha. This is, which one is this? This is the energy drink with no sugar, no taurine. Now, that's an important thing because taurine's got a bit of a bad rep lately. And natural flavors. I forgot to mention that all of these are natural flavors. And being the lawyer that I am, I have checked all of the ingredients on here. You can bet that I've looked these things up. They are things like the root extracts, even the sweeteners, stevia, which is a natural thing. Let's have a taste of the pomegranate piranha. I love pomegranate, so let's see how this fares. That really does taste like pomegranate. I love pomegranates. I could drink that as an energy drink. I really could. Right. Now, I should have a palate cleanser, really, but I won't. Now I'm going to try the iced tea because I like drinking herbal teas and things like that in the evening. And if I want it iced, I use hot water first and then I get ice cubes and that sort of stuff. But that's a real faff because you have to make the tea with hot water and then you got to put ice cubes in it, make sure it's cold, etc., etc. But this is with cold water. You put the powder in, you mix it up, you give it a shake. And this is sugar-free iced tea. And for this one, I choose the red grapes and hibiscus. I love red grapes as well, so it better live up to my expectations because I love red grapes. Let's give this a try. I can tell the difference with it being a tea. I could really see myself sipping this slowly in an evening, Netflix or something, and just sipping away. It's genuinely really nice. I would not just say that to you. As I've said to you many times on this channel before, I would not have any partner to my channel here that I wouldn't use myself. That's my promise to you. I would never recommend something to you on my channel here that I wouldn't use myself. Now, Holly asked me for my favorite. What's my favorite? I think I'm going to come back to this one, which was the kiwi. Now, I love all fruit. I love all fruits, but this was the sugar-free hydration drink with electrolytes and minerals with strawberry and kiwi. And this one? This one is lighter, it's easier to drink, but it will keep you coming back for more, which that's the idea. The idea is to drink more water. It's not to be boring. If you want to kick out alcohol and replace it with something, these will really literally fruit and spice up your hydration without being boring and give you something to replace that habit with. Obviously, I got you a discount. Just use the code Barrister5 for a £5 discount off your first order. And then thereafter, just the code Barrister will give you 10% off your orders thereafter. And of course, there's a unique link in the description to make it easy for you to follow and sign up. So give it a try. I genuinely think they're fantastic. And it will encourage you to drink more water, which is the best and healthy thing for you to do. So genuinely, thank you to Holly for reaching out and offering to partner with my channel. Now back to the video. So let's take, for example, this tripod here. It is just a tripod. And by itself, it is just a tripod. But if I were to take it out and hit somebody with it, obviously it would hurt them. If I took this out with the intention of hurting somebody with it, that might make this an offensive weapon. It's not an offensive weapon per se, because it's not designed as an offensive weapon. It is not adapted to be an offensive weapon, at least not yet. And I'm normally not carrying it with the intent of using it as an offensive weapon. So it doesn't meet any of the 3 standard tests to be an offensive weapon. But does that mean I can't use it in self-defense? No, not necessarily. Because if this is just the only thing that I happen to have to hand, and I think that it is necessary to use force, and that I, in that split moment, in the circumstances that I genuinely believe them to be, I feel that it's necessary to use some force to defend myself, and this is the only thing I have to hand with which to do so, and I bop this guy with this thing because I act instinctively to defend myself and I feel that that's necessary, then the law will generally understand that I've acted in self-defense, provided, of course, that the force used is proportionate. So what on earth does that mean? Well, let's back up for a moment. The test for self-defense is a 2-part test. First is subjective. What did you really think at that time? Did you genuinely believe that there was a need to use force? Now, in my story case, the guy had literally punched me in the head. So that was quite clear, my understanding of that situation. I was being physically assaulted and mugged at the same time. So in that case, it was unquestionably necessary to use force to defend myself because I believed he was going to continue unless I did something about it. Now, some of the more astute among you will recognize the fact that I gave chase and chased the guy down. Now, you could still argue that it was necessary to use force to protect my property because I believed he had my property. Now, it turns out I was mistaken that he had my property, but it was a perfectly reasonable mistake to make because after all, actually I left a bit out. He put his hand in his pocket before he ran off. So I saw him put his hand in his pocket, then ran off, and my split second was he's put something in his pocket that belongs to me after punching me in the head or whilst punching me in the head or whatever, and ran off. So I genuinely believed that he had some of my property and I wanted to go and get it back. So I felt it was necessary to use some force to go and get it back. And notwithstanding, he just assaulted me, and so I wanted to detain him for the police to arrive, which they did, and they carted him away. But let's look at the use of force and whether it's proportionate. Now, whether or not something is proportionate force will be an objective test, i.e. it will be left to the jury to decide whether a reasonable person would think that that was proportionate force in the circumstances that you genuinely believe them to be, and that you genuinely believe that it was necessary to use force. If in the example using the tripod here that I mentioned, if you hit the guy once and he fell on the floor and stopped moving and then the attack is over, that should probably be it. If while he was on the floor, you keep hitting him with this thing, that is not likely to be proportionate force. Of course, it does depend on the specific facts and circumstances and what he was doing at the time. For example, if he was just trying to take something from your pocket and you keep hitting him on the floor, probably not proportionate force. If he had a large or lethal weapon and was trying to or was threatening to attack somebody with it, that might be an immediate threat to life, and then multiple blows might well be justified in those circumstances to subdue this guy from attacking anybody else any further. Now, there is a distinction when it comes to proportionate force when defending your home. That's known as a householder case, and that is under Section 76 of the Criminal Justice and Immigration Act 2008. Section 76(5)(a) allows householders to use disproportionate force when defending yourselves against an intruder or something else in your home. And so the test now for householder cases is still an objective test, but it's whether or not it was grossly disproportionate. So you'd have to really go some way to hurting somebody deliberately and maliciously and far more than is necessary, and commonly known as going far too far. So if you have subdued a burglar and he's unconscious on the floor of your house, and you continue to attack that burglar to the point that he's fighting for life, you've gone too far. That would be grossly disproportionate. But any prosecution will still have to stand up to the same code for Crown prosecutors, being a two-part test. Very briefly, that is there enough evidence for a tribunal to convict you upon the evidence before it on the offence charged? And secondly, is it in the public interest to prosecute you? So if you've not unalived this person, you've just really hurt them and they were threatening you and your family and they were burgling your home and etc., it may well not be in the public interest to prosecute you for defending your own home. And I believe that that's quite right. It shouldn't be in the public interest to do that. If, on the other hand, they've merely walked in and, I don't know, they've got the wrong house, or they were just coming inside and having a nose around or whatever, and you immediately move to lethal force, then it's probably in the public interest that that's not allowed. At least in this country, at the moment, we don't allow that. Another question I get a lot is, what if you think someone's going to attack you, but you're not sure and they haven't yet attacked you? What can you do then? Well, the law doesn't require you to wait to be attacked first. You are allowed to use a preemptive strike. You can strike when you believe, as long as you genuinely believe someone's going to attack you or that force is necessary to defend yourself or someone else, you can use a preemptive strike. You can hit them first. It is going to be to you to raise the evidence of self-defense that you were acting in self-defense when you believed they were going to attack you. And then people ask, well, whose burden of proof is it? Who has to prove what? Well, if you get charged with assaulting them and you say you were acting in self-defense, you only have an evidential burden of raising the defense of self-defense. The burden of proof then shifts back to the prosecution, as it was when bringing the prosecution, to disprove your use of self-defense to the same criminal standard. In other words, the prosecution must prove beyond any reasonable doubt, so that a jury is sure that you are not acting in self-defense. And so it is not for you to prove to the criminal standard, it is only for you to raise it as self-defense, and the prosecution must disprove it. And again, even before we get to that stage, you would have the test for Crown prosecutors, the evidential and the public interest test. So if it was quite clear that you were acting in self-defense, then really it shouldn't be in the public interest to prosecute you, unless, of course, you've gone far too far, in which case those are the cases the CPS are most likely to authorize a prosecution. Now, there's a very interesting section on the CPS website with regard to the use of force against those committing crime, which I felt better pull up on screen and talk about it. It reads as follows. Prosecutors should exercise particular care when assessing the reasonableness of the force used in those cases in which the alleged victim was or believed by the accused to have been at the material time engaged in committing a crime. In other words, the person complaining they've been hurt was committing a crime or believed to have been committing a crime. A witness to a violent crime with a continuing threat of violence may well be justified in using extreme force to remove a threat of further violence. In assessing whether it's necessary to use force, prosecutors should bear in mind the period of time for which the person had to decide whether to act against another who he or she thought to be committing the offence. In other words, you might only have the briefest of moments. You are likely to only have had the briefest of moments to decide whether or not to act against the other person that you believe to be committing an offence. And the circumstances of each case will be considered very carefully. And so that is exactly my point. You may only have a split second or a few moments, which is a series of split seconds. We're not really talking about minutes here. We are talking about a very short period of time within which you will have to decide whether or not there's an ongoing threat of force, whether or not you're going to get involved, whether or not you're going to use force, whether it's necessary, and what force you use. And so you may only have a tripod or a water bottle with you, which you decide to clobber somebody with. But either way, you'll normally only get those few moments to decide what you're going to do. And I very often get questions about the citizen power of arrest, because the old arrestable offence has disappeared, because people often misunderstand that police need an arrestable offence to be able to arrest somebody, and that civilians can't arrest someone that they have the suspicion of being involved in an offence, which is not really true. Because Section 24A of PACE, Police and Criminal Evidence Act 1984, provides for an arrest without a warrant for other persons, i.e. not a constable. So a person other than a constable, so a member of the public, may arrest without a warrant anyone who is in the act of committing an indictable offence, that is one that can be heard in the Magistrates' Court or the Crown Court, and anyone whom he has reasonable grounds for suspecting to be committing an indictable offence. And where an indictable offence has been committed, a person other than a constable may arrest without a warrant anyone who is guilty of the offence or anyone whom he has reasonable grounds for suspecting to be guilty of it. And so when we put this into context, let's say you're in a shop and you see somebody stealing something, or you have reasonable grounds for suspecting they are committing an indictable offence, which includes shoplifting. Even though, for law students among you, it's a bit of an outlier offence in that it is ordinarily treated summarily if the value is under £200, but it's still an indictable offence because it's an offence of theft. In the event that they are in the store and you have reasonable grounds for suspecting that they are committing an indictable offence, even though they have not yet left the store. This is a common myth that they have to leave the store. They don't. If they are in the store and they've put something like the water bottle and they've put it in their bag or something, and they've taken it off the shelf and they've put it in their bag, then if you have reasonable grounds for suspecting them to be committing an indictable offence of shoplifting, which is the offence of theft, you are permitted to exercise an arrest without a warrant, regardless of your police officer, and just because you have reasonable grounds for suspecting that they are committing this indictable offence. There are two conditions that apply for a citizen's arrest, although we don't really call it that, but there are two conditions. One is that there must be reasonable grounds to believe that the arrest is necessary for a reason specified, and I'll come back to those in a minute because it's not just the offences, but a reason specified. And two, it is not reasonably practical for a constable to make the arrest. In other words, there's no police officer nearby. So there's no police officer around, so you decide to do it. Now, the reasons specified are also on the CPS website. The reasons include to prevent the person in question from causing physical injury to himself or another person, suffering physical injury, causing loss or damage to property, So that would include the scenario where somebody is emptying the shelves of things into their bag and you quite reasonably suspect that they're going to take those items, steal them and take them from the store, causing loss to the store, and they're in the process of committing an offence. And of course, making off before a constable can assume responsibility. But it is worth bearing in mind at all times that any force used to effect an arrest may ultimately result in an assault and be unlawful. But provided that you can demonstrate what you believed and there's sufficient evidence to back it up, you should usually be fine. And so remember that you should be able to justify what you've done, and ideally there should be some evidence there to back you up, even if that's in the evidence of other witnesses or CCTV, which there's likely to be in the majority of shops these days. Now, I do make the caveat that I'm not encouraging people to go out and be vigilante police officers here, but that's what the law says. It does allow any person to arrest without a warrant for any of those reasons. There are many more questions that people throw at me regarding self-defense, one of which is retreating. If you didn't run away, does that defeat your argument of self-defense? The short answer in typical legal fashion is it depends. A failure to run away is not going to be conclusive evidence that you were not acting in self-defense. Although, if you did have a perfect opportunity to run away and didn't, and you, quote, stayed for the fight, that might go against you. That might mean you took the choice to stay there and fight when you could have just left the scene. Now, as a veteran martial artist, I will tell you, if you are engaged in this kind of thing and you have the opportunity to get away, regardless of how many years you've been training and regardless of how competent you think you are, my recommendation is, if you can get away, then you should get away. Of course, unless there's an ongoing danger and threat to you, your family, your property, and you just have to defend it and them, then obviously you have no choice. But coming back to the question, you're not required to run away. It just might harm your defense of self-defense if you stick around for the fight. Now, talking about being around for the fight, the next question is about revenge. This came from a case of Crown and Rashford in 2005. It says, the mere fact that a defendant went somewhere to exact revenge from the victim didn't rule out the possibility that in any violence that came about, self-defense was necessarily unavailable as a defense. So self-defense is something that will always be decided on its own merits in the case and the circumstances and the factual matrix of that case. However, and just to be clear, the defendant that starts the violence and is the aggressor in the situation cannot rely on self-defense to render his own actions lawful. This is why you need legal advice. So in other words, just stick away from seeking revenge, don't bother, and try to get away if you can, but if you can't, so then obviously you can respond to the threat, you just have to justify it later. And I think the final tip that I can leave you with is to try to be aware of your surroundings and your situation. Try to be more mindful of what's going on around you, the people around you, what their intentions are, because if their intentions are nefarious, they will be much more likely to tell if you are paying attention or enough attention to them. If they do, they'll probably leave you alone. They'll be looking for the targets that are less aware of their surroundings and less likely to be susceptible from a mugging, an attack, and so on. We run a great course with Polearm Academy. I'll link it in the description below. It's an elite combat training course that we've put together with military veterans and special and elite forces veterans. It teaches you not just how to fight and defend yourself and defend and protect your family using weapons and also situational awareness and behavioral detection. It's a fantastic course that I've helped put together for Polearm Academy, so that link is in the description below. If you really want to defend yourself and others, this is a fantastic way of doing it. The other way is a long-winded way of doing martial arts over many, many years and developing those skills over a long period of time. This is very much more a crash course for those that are really serious about protecting yourself and your family. So I hope you find that useful. Check out that and also check out Holy in the description below. I've been sipping away at it while I've been doing this video. It really is quite fantastic. So check them out. Thank you for watching. Be safe out there and I'll see you next time.